A warm welcome to you all, maritime law enthusiasts who have come over here for this special lecture from our dear Syam sir. He was in the academic field and he's still associated with NUALS and neighboring institutions teaching maritime law. And there is a lot of students in the legal fraternity who have been students of his. And we are really grateful that he has found the time to spare, in spite of his busy schedules, to give an overview with respect to the new changes and the current events that are impacting maritime law. We have gratefully the Indian Law Institute taken the initiative for arranging this special lecture. And ILI, as you know, the state unit especially, has been really in the forefront of introducing the legal reforms that has happened over here, periodically arranging these special lectures. And hopefully, this won't be the last one. We'll have a periodic arrangement of these kinds of lectures in collaboration with NUALS. Now I take this opportunity to welcome Syam sir to this venue. G.V. Reddy sir has been a tireless worker, probably doing more events or initiating the conduct of more events over the last few months of his tenure here as compared to what was the position earlier. He is a source of inspiration, a workaholic to boot, who is forcing all of us to do our best. So I welcome you to this session. Harinarayan sir has been a long-time practitioner of maritime law and somebody who is also academically inclined, writing, somebody who has been a go-to authority with respect to getting inputs on maritime law. I've had multiple occasions of contacting him, but we met officially only today, though over the phone I have had contacts with him, especially in cases where Syam sir is so busy that he is not able to provide an input. Then next go-to, because Syam sir was there as a colleague and was always available, but then if he was not available, then Harisa was somebody whom I have contacted frequently. So welcome to this session, sir. We have dignitaries in our midst in the hall, some of whom have association with NUALS from its inception time. I welcome all of you here, alumni and students also from other institutions. We want NUALS to be a hub for all the other law colleges around, and I'm really grateful that students and thankful that students from other institutions are taking the initiative to come over here, and really glad that you are all here eagerly waiting for Syam sir's lecture. I welcome you all. Thank you.
Syam Kumar V, Judge, High Court of Kerala. Advocate Sri V.B. Harinarayanan, Professor Anil Nair, all the leading lights of the Indian Law Institute, Kerala branch, respected invitees, alumni, faculty members, and students. I'm extremely happy to be part of this wonderful special lecture, Navigating Change, India's New Maritime Laws and Global Integration, organized by the Center for Parliamentary Studies and Law Reforms of NUALS and the Indian Law Institute, Kerala State Unit. And as far as the name of ILI is concerned, it reminds us about something elite as far as the Indian legal research institutions are concerned. It's a think tank for almost all the judges of the Supreme Court in Delhi and elsewhere. And after becoming a deemed university, I think it has strengthened its activities, academic research and other related across the country. And I'm happy to note that the Kerala state unit of ILI is the most active among the state units, and the very fact that our Center for Parliamentary Studies and Law Reforms is collaborating with ILI Kerala State Unit, there is a meaningful and constructive collaboration between both. The objectives of both the institutions are the same. Personally, my association with ILI dates back to almost 15 years when I started contributing to Annual Survey of Indian Law in 2011 on environmental laws, and it still continues. And whenever we mention about the databases of the latest developments in any chosen area of law, the natural reference is to the annual survey on various aspects. And we are happy to have Honorable Justice Syam Kumar Sir with us once again. He has been a continuing part of this institution as an eminent faculty on maritime laws, and whenever there is an occasion, Sir never disappointed us, and it is always a pleasure to have him with us on any occasion relating to maritime and other laws. And we are equally happy that the ILI State Unit of Kerala is willing and eager to collaborate with NUALS, which we reciprocate with great respect, for some more meaningful and constructive programs in the near future. And I am looking forward to a few such programs in this year itself. And without taking much of your precious time, now I duplicate what Professor Anil Nair has said. I welcome once again Honorable Justice Syam Kumar Sir, the other members and the leading lights of ILI Kerala, and I wish this program a great success. Thank you so much.
My dear friend Anil, my classmate and brother Harinarayanan, Advocate Unnikrishnan, Advocate Parvati, Senior Advocate, my dear friend, and all my fellow students who are there, some of whom I recognize very well, and the students of this university. And I'm told that some of the students are here from the Government Law College also. Coming to the NUALS, especially to talk on a topic on maritime law, is always a pleasure and a privilege. It is even more so when Indian Law Institute, Kerala State Unit, of which I was a member, and in the working of which I had a small role to play since the last around 6 or 7 years, invites me through Advocate Unnikrishnan and Advocate Parvati, who are the flag bearers of that institute. And Indian Law Institute Kerala State Unit is one of the most active units of the Indian Law Institute. And the topic for discussion today is Navigating Challenge, India's New Maritime Laws and Global Integration. I've been earning my bread and butter practicing maritime law for the last around 25 years. And I had the privilege of teaching maritime law for around 15 or 16 years. And a major part of which I had spent here in NUALS and in Kochi University School of Legal Studies. I'm always indebted to the students of this university because it is they who, through their inquisitive minds and their eagerness in learning more kept me on my feet and gave me the capacity to think on my feet when I am at my classes. I find it a matter of honor and great pleasure to be here and to address you all. I guess that before I delve into the topic of discussion today, I need to say a few words on what maritime law is, just to put it in context. What I propose to do here in the time allotted to me is to take you through the new maritime statutes, most of which have been enacted in the year 2025, which I would say 2025 is a watershed moment as far as maritime law in India is concerned, for the reason that since around 100 years, we never had the much needed updating of maritime legislations in India. That have happened after long in 2025. So it now becomes our duty as students of law to examine them on more than one counts, so as to see as to how these statutes update the Indian law and also meet the felt necessities of the times that we live in, so that the maritime trade in India is able to cope up with the challenges that are thrown to it in the ever-shifting global maritime world. Even as we speak, I learned from the newspapers today that we are in a situation where a vessel of a foreign country has sought refuge within the Cochin port, and a refuge has been granted. Another vessel belonging to the same country, which was along the Sri Lankan coast, had been torpedoed, leading to the loss of around 87 sailors on board. Questions, many a times intricate ones, relating to maritime law and law of the sea crop up, making it necessary for us to update our laws so that such kinds of issues could be addressed as and when they crop up. Maritime law is a nebulous term which is used to denote a cluster of legal norms or statutes which concern the sea and the ships. So as the Socratic dialogue starts, we should define our terms before we proceed to discuss it further. I propose to address you on these statutes, which I mentioned earlier, are the ones that are updations in 2025. The Merchant Shipping Act, which used to be of 1958, received an updation in 2025. The Indian Ports Act, which was in legislation of 1908, received an updation in 2025. The Carriage of Goods by Sea Act, mind you, after 100 years, because the earlier Carriage of Goods by Sea Act was of 1925, received an updation last year. The Bills of Lading Act, it takes us again further. Bills of Lading Act of 1856 was updated last year. And lastly, we have a new legislation, that is the Coastal Shipping Act of 2025. We never had a separate legislation for coastal shipping here too before. Coastal shipping or coastal maritime trade, as we call it, is cabotage. Cabotage was already covered under the Merchant Shipping Act. Now we have a separate statute dealing with it. These are some of the statutes of the year 2025. Not as if that these are the only ones that are the recent additions to our bouquet of maritime laws. These are the few that came out in 2025. Here I have a list of some relevant legislations invariably to be discussed if we are proceeding to discuss on how far or how updated we are with the maritime legal norms that are internationally prevalent. We have to start with the 1976 Maritime Zones Act. The name of the statute is Territorial Waters, Continental Shelf, Exclusive Economic Zone and Other Maritime Zones Act, 1976. As a student, I used to commit the very same mistake of looking for Maritime Zones Act in the AER manual under the title M. It never starts with an M, even though we generally call it as the Maritime Zones Act. It starts with a T. So you have to look at the statute starting with a T in the alphabetic order. Then you have the Major Port Authorities Act 2021, which is a legislation that supplants the Major Port Trust Act 1963. Because there are minor ports and major ports across India. Major ports were under trusts. They were port trusts. They comprised of representatives of the labor unions, the shipping community. There would be governmental representatives. So it used to be a trust. That's why that statute was earlier the Major Port Trust Act. We always speak of the Cochin Port Trust. It's no longer the Cochin Port Trust. Now it is the Cochin Port Authority. So that change was brought in, and substantial redoing of the statute, of the provisions of the 1963 Act was done in the Major Port Authorities Act 2021. Now comes the 2017 Admiralty Act. That is again an addition, or rather an updation of a law, the earlier law that was as old as 1891, because the Colonial Codes of Admiralty Act 1891 used to be the statute that is in force, that was in force in India, which just followed the Colonial Codes of Admiralty Act 1890, which was an English legislation made for the purpose of all colonial chartered high courts, including Rangoon and also the court in, I think, in South Africa it is Johannesburg. Hari would be knowing. So this was a statute which was intended to confer admiralty jurisdiction on all the colonial high courts. And in India, a statute was enacted in 1891. Actually, there was a statute in England as early as in 1860, the Admiralty Codes Act of 1860 and 1863 and 65, which were updations. And those statutes, whatever powers were vested in the chartered high courts of UK, were conferred on the other colonial high courts also. So that statute of 1891 was updated by the 2017 statute, which incidentally is the main statute when it comes to admiralty law, which effectively gave a relief to the lawyers like Hari, who used to rely on the MV Elizabeth versus Harvan Investments decision for the purpose of substantiating any admiralty suit that is filed at least before non-chartered high courts. Because when the question arises as to where do you place your jurisdictional power when it comes to exercise of admiralty jurisdiction, invariably, even during the best part of my practice, I had to rely on MV Elizabeth versus Harvan Investments, a year 1993 Supreme Court 1014. Now, we don't have to touch on to MV Elizabeth. Many of the observations made therein by Justice Kochutomman, who was a judge from Kerala, who went to Supreme Court, and he delivered the MV Elizabeth decision. Many of those observations are now made to stand on its head in the new legislation, 2017 Act. It's another watershed moment as far as admiralty jurisdiction is concerned, a statute which requires thorough study and scrutiny. Again, a statute which claims to have updated Indian admiralty law to the admiralty jurisdictional norms as are existing in the international level. Then the next statute is the suppression of unlawful acts against safety of maritime navigation and fixed platforms on continental shelf act, which we call as the SUA Act. Incidentally, SUA Act was one of those statutes, as far as India is concerned, which made a provision for dealing with admiralty offences. We had an English Admiralty Offences Act of 1884 or something, I don't remember, I may not be correct with that year actually. We had an Admiralty Offences Act which was of English origin, and that continued until recently. But the problem with respect to that statute was, it did not define the word piracy as such. Piracy jure gentium, as we call it. Pirates are the enemies of mankind. This concept, though it has been well entrenched in English jurisprudence, in India, we never had the definition of a pirate, or what amounts to piracy was never defined in Indian law. The IPC does not define a pirate. So who is a pirate was a huge problem, just as the definition of a terrorist is a problem. One man's terrorist is another man's freedom fighter. So we have been struggling with defining who is a terrorist and what is a terrorist act. Similarly, we had this huge problem of defining a pirate and piracy. One of the first attempts internationally to define piracy was made in the United Nations Convention on Law of the Sea. Maybe I will be able to touch upon it when I come to that area. I just will skip. So 2002 SUA Act was one of those legislations made by Indian Parliament for the purpose of abiding by our commitments under the SUA Convention of Rome, the Rome SUA Convention, which was a convention that was necessitated out of the Ochille Loro incident. Because the definition of piracy, I guess I will deal with it even now since I am on the point. Definition of piracy as it stood under the UNCLOS envisaged two ships, where people coming on board one ship, a private ship for that matter, attacks another ship. So the definition as it stood in, if I remember right, 111 of the UNCLOS or somewhere around, it said there should be two vessels for the purpose of committing a piratical act. Thereafter, an incident happened where the Palestine Liberation Organization rebels, they seized a vessel, which was a passenger vessel, a cruise vessel, and they killed an elderly man on board. He was just thrown out into the sea. Incidentally, he was an American citizen. America intervened, as it does now. May not be as forcefully as it does now, but more based on the rules, on a rule-based order. They intervened, and these terrorists, they managed to bargain for a safe escape on board a vessel. I think they boarded on a plane somewhere from Spain, and this plane was followed by American aircrafts, fighter aircrafts, and these terrorists were made to compulsorily land somewhere, and lot took its own course. Now came the question, are they pirates? Because there is no two vessel. These people were on board the same vessel, and they had attacked the people on board and had seized the vessel. So the definition of piracy as it stood then under the UNCLOS was insufficient to deal with this situation. That led essentially to the International Convention in Rome, which is the SUA Convention, based on which we enacted, based on our commitments. We were a signatory to the SUA Convention. We had the 2002. Now comes the question, insofar as there is a SUA Convention which deals with any kinds of illegalities against ships or any crimes committed against ships, is there a need to define piracy? India feels so. And we have the Maritime Anti-Piracy Act of 2022. Incidentally, the definition of piracy in this act is the same definition in UNCLOS, which throws up lots of questions regarding our method and the manner in which we are churning out legislations, one after the another. A definition of piracy which has been found to be inadequate and which has been rather been termed redundant and insufficient to meet the requirements of the day and has been discarded and supplanted with the SUA Convention and our own Parliament by the SUA Act. In 2022, we are again going back to that definition and incorporating it in the Maritime Anti-Piracy Act. We will come to that later. The next legislation which has great relevance is the Multimodal Transportation of Goods Act 1993, which deals with containerization. Multimodal in the sense not M-O-D-E-L, M-O-D-A-L, in the sense that different modes of transport. Containerization had necessitated such a statute so as to deal with the responsibility and liability of the carrier. Because the liability regime which stood earlier was based on separate statutes. Like, for example, the road carrier had a liability which was different from that of a rail carrier under the Railways Act, which again was different from that of the sea carrier under the Carriage of Goods by Sea Act, and also again different from that of the air carrier. Why do you think that there should be different liability regimes depending on the mode of transport? Anyone? Any of the students here? Why do you think that the liability regime changes as far as the carrier's liability under each of these modes of transport is concerned? Anybody willing to take a guess? Yes, please. Very good, very good, very good. You are very close to that, to the answer. The point is, let us assume a situation where a container is being transported by lorry from Ludhiana to Kochi, in Punjab to Kochi. The road carrier has a liability. From Kochi, it is placed on board a vessel, and the vessel takes it to, say, New York. The sea carrier has a liability. The liability and the risk taken by these two carriers are totally different. The road carrier has a comparatively lesser risk, but the risk that is taken by the sea carrier is much more. So the statutes pertaining to such carriage factor in these risks that are taken by each of these carriers. So the liability regime under each of these statutes are different. We had no problem with that. Life went on smoothly, commerce went on smoothly until it became the era of containerization. Because formerly it used to be cargo used to be transported in bulk, or rather consolidated together in gunny bags along with a net. I hope that many of us here, like Hari and others who are familiar with the films of the 1970s and 80s, we would know these action scenes happening in the port where you would come across lots of sacks bundled together in a net, kept together. We never saw any containers at that point of time. So that was the way in which cargo was being consolidated and transported. And incidentally, that was the time when the maritime lawyers had a heyday. If you look at the Kerala law times of 1970s, I would say rather from the 60s, 70s and 80s, you would come across a number of cases from Kerala High Court discussing carriage of goods by sea disputes. But after the 80s, especially after the 90s, you come across a case very rarely under Carriage of Goods by Sea Act. The reason is containerization had substantially reduced the risk of pilferage, short landing, damage to cargo, etc. So the number of cases came down. As if you are carrying this cargo in gunny bags, open to the vicissitudes of the nature, the possibilities of it being affected by the rain or the wind or whatever is much more. And the chances of it being pilfered is also there. In a container, the cargo is very safe. So that actually affected maritime lawyers like me and Hari, because the cases substantially dwindled. But now, if something is lost, the container itself is lost. So the cargo, the amount that is involved is substantial, unlike the other matters which were small in terms of the value or the amount involved. So the point is, the Multimodal Transportation of Goods Act 1993 was again a substantial development when it comes to the legal norms governing containerized transport, and incidentally the manner in which this statute was brought in, whereby if you look at the schedule of the statute, you find certain amendments made to the Carriage of Goods by Sea Act and all. That was rather a strange way of one statute of 1993 by incorporating in the schedule certain provisions, amending the provisions of an erstwhile earlier statute. Then you have the 1981 Maritime Zones Act, regulation of fishing by foreign vessels is a, I'm so sorry, the spelling of vessels is wrong there, I guess. There's an R in between. This is an important statute and a very unique statute in the sense that this is one of those statutes which would have operation beyond the Indian territory. In the sense that any law made by Indian Parliament or by the states would have its effect only within the Indian territory, which includes the 12 nautical mile territorial sea of India. But India has a 200 nautical mile exclusive economic zone, and the United Nations Convention on Law of the Sea would empower every coastal state which has an exclusive economic zone to enact rules so as to regulate the uses of the economic resources of that area. So this statute of 1981 is much in news now for the reason that the coastal fishing has substantially dwindled and fishermen are compelled to go out into the deep sea, farther areas of the sea for the purpose of earning their livelihood, where they confront the foreign vessels, or rather the mechanized vessels, or the floating factories as we call them, which catch fish in abundance, in tons literally, process these fishes on board itself, can them, and by the time the vessel reaches the port, the fish is available in cans, ready to reach the supermarket shelves. So the fishermen, the traditional fishermen, have to fight with these people out in the high seas. So that is the reason why there is a big demand so as to update the 1981 statute. Then is the Marine Insurance Act of 1963, which is a very interesting statute which almost in verbatim follows the Marine Insurance Act 1906 of England. And even though in England they have gone up with substantial amendments and changes, we have not touched it for the time being, but there are some aspects regarding protection and indemnity in which Indian government is at present planning to update the law. And another statute is the Customs Act 1962, which is a world of its own, which is related to shipping, but I don't think that we may be able to dwell with it much because we don't have the time for that. So, this is essentially what I propose to do. We will just discuss about the nature and relevance of the 2025 statutes, the aim of achieving global integration, how far we have succeeded, and whether the updating of these laws have met the challenges of the 21st century. Before proceeding in this respect, I should attempt to categorize the statutes that we have, that list of statutes. We can generally categorize them as public law statutes and private law statutes. Public law statutes in the sense, the statutes which intend to regulate the activity, which doesn't essentially deal with the individuals who are involved in the maritime commerce or inter se relationship of these individuals. And there we have the other set of statutes like the Carriage of Goods by Sea Act, the Bill of Lading Act, etc., which directly touch upon the contracts that are entered into between private individuals and corporations with respect to maritime commerce. So it has both public law facets and private law facets. Now, since we have discussed this much, what do you think on this? Can we use the term maritime law interchangeably with law of the sea, admiralty law, shipping law, law of carriage by sea? What do you think? Because we generally tend to use it. People use the word admiralty law so as to mean maritime law. Essentially, maritime law is a compendious term which, unlike taxation law or labor law, does not deal with a homogeneous norms concerning particular activity. It is more similar to the term environmental law, which takes in lots of facets of concerning the environment. So maritime law generally deals with lots of aspects. I guess that I have a slide for you here, which, though imperfectly done, shows you the complexity of the subject that we are dealing with. So it's as if that maritime law, or rather shipping law, touches on almost all other branches of law. I don't know whether you have noticed recently, Hari would have noticed for sure, we had a very landmark decision from the Bombay High Court with respect to Admiralty Act and the IBC, Insolvency and Bankruptcy Code. The interplay between these two statutes. So maritime law is something that encompasses within itself lots of other branches and norms of law, and this is something that we are discussing here today. We are not into other aspects, like we are not touching on arbitration law. Obviously, there is that big branch of arbitration known as the maritime arbitration. It's a world in itself, and it's developing day by day. New norms are coming in, new countries are vying for maritime arbitration. India itself is gearing up so as to attract maritime arbitration matters. People like Hari would be benefited substantially when it comes. We are not touching on that. There is, how does criminal law factor in? Anybody? Criminal law and shipping. Do you think that they are totally incompatible? Or do you think that there could be some facets or some aspects of maritime activity which could touch upon criminal law? Anybody? Any students? Can you give me any examples?
The time when Italian ship.
Very good, very good, very good. Any other areas? Or rather, environmental law. I am not touching on it because we don't have the time for that. Oil spill, very good, ma'am, very good. Oil spill. Marine ecology, marine damage. It's an area that is capable of study on its own. It may be a branch of environmental law also, but marine environment and its protection and the norms relating to oil spills, the civil liability for oil pollution, all those aspects, I will just touch upon it as we go. Then is the private international law. One of the most complex branches of law. Any law student knows the subject that we despised the most when we studied LLB. I don't know whether Hari would be remembering. We had private international law. I hated the subject like the renvoi, the double renvoi and things like that. But however much I may dislike it, I had to deal with it over the last 25 years because each and every dispute pertaining to maritime commercial transportation cases are cases of private international law. It has more than one jurisdictions involved and the laws would be different. All those complexities of renvoi become applicable. Anyway, we will leave it there. So moving on, just to show some of those aspects again within that contracts in shipping. Subsidiary contracts that would evolve out of shipping, like for example, towage, pilotage, manning, ship mortgages, marine salvage, carriage of course, carriage of goods by sea, bills of lading, etc., supply of necessaries. These are all independent areas capable of study. Like for example, pilotage. Let us take a random example from this group. Pilotage. What do you understand by pilotage? We have heard of a pilot who pilots an aircraft. There is a pilot for a vessel also, in the sense that entry and exiting of a vessel from a port is something that is guided by a pilot. And believe me, pilotage is a branch of law which developed in in UK, for the reason that London is a riverine port. Pilotage assumes great relevance when, can anyone suggest a riverine port in India? A port which can be reached only by passing through a river. Very good. Haldia. Haldia is a riverine port. London was a riverine port, east one. So you have to pass through Thames. Thames is a narrow river and collisions occur. And you cannot afford to have collisions in Thames. Just as we know from the incident in Pearl Harbor, or maybe even now in Hormuz, if you sink a vessel in the channel, the port becomes unusable. So you don't have to bomb the port. You just need to sink a vessel in the channel. So no vessel can come in and no vessel can go out. The port becomes strategically of no use for the country. So similarly, for the reason that such incidents should not happen, you have the pilotage rules that are in force. Now comes the complex tortious liability. I had pointed out that law of torts would also be applicable in maritime law, where when a vessel collides with another, when it is under pilotage, because pilot is not someone who is appointed by the shipowner. Pilot is taken by the ship from the port or from the dock regulating authority. He is not an employee of the shipowner. So is the shipowner and the ship liable for the negligence of the pilot has been an area on which substantial judicial ink has been spent in UK. You have books and books on this subject. And in India, as we speak, we don't have a law relating to pilotage, so as to govern pilotage. Even though we know in Kochi that we have a number of instances where vessels have collided with the bridges here. Vessels have collided during pilotage with the port property, causing substantial damage. Multing liability we have number of cases in the subordinate judges court, Kochi, where these pilotage issues come. And we don't have a law relating to pilotage. And regarding, please. Pilotage essentially is, the best example is when Vasco da Gama comes to Cochin, to Kapad in 1498, it's not as if that he rides the vessel in and just alights. He would wait out there when they see a land far from the sea. They want to know whether it is safe to enter, whether the draft would permit the vessel to enter. So they need some local people who would be able to guide them in and guide them out, because they don't know the way the currents behave. They don't know the draft. So the earliest of the pilots were the local fishermen who would come in and assist the vessel by saying that this is the place where the vessel can be safely anchored. That used to be the earlier times. Modern day pilot is the person, for example, a good example is Cochin. Cochin port they are very, very qualified. They are specially trained so as to deal with the local scenario, because the local situation keeps on changing. If we look at Cochin, you have the undercurrents that come, which brings the silt and those sediments. So the underwater topography may keep on changing. A foreign vessel under the master who's not a local, he never knows as to what the situation is. It is more in the interest of the local port to have a pilot, and it's also prudent for the vessel to take on a pilot so that it can safely go in and go out. And if you look through the YouTube channels, YouTube videos, the way in which the pilot boards the vessel and boards out of it is a very tricky exercise, because the vessel would be moving and the boat would be coming by the side, and he literally jumps from the vessel to the boat and maybe from the boat to the vessel through the ladder. It's a very tricky exercise that he does, a very risky one also, so they are paid substantially. So that is something that is peculiar to the maritime activity. As lawyers, we may not be much concerned about the way in which he works, but we are more concerned about the situations that arise when the vessel is under the control of a pilot. The most interesting question is, when the pilot comes on board, since you asked, pilot comes on board, what is the status of the captain and the crew? Can they just sit back as passengers that the pilot would take over the vessel? Or should it be a cooperative activity where, for example, everything would be okay, everything would be hunky-dory as long as the vessel comes in and goes out. If something goes wrong and a vessel collides with another vessel or with a port property, the liability is in crores. Then comes the game of passing the buck. The ship owner would say that this was compulsory pilotage. I could not have entered the vessel, entered the port, unless you send me a pilot. So this is a compulsory pilotage situation where you gave me a pilot who proved to be a drunkard, or he was not in his senses when he came on board the vessel so as to take charge of the navigation part. So I cannot be made liable. And he shifts the liability onto the port authority. On the other hand, the pilot would say, I never knew that the second engine of the vessel was not working. I never knew the nature of the cargo that was there on board the vessel was capable of shifting. It has not been properly trimmed, or the vessel had an inherent problem. Unless you give me this information, I am not in a position to navigate safely. So there is a fault on your part. Innumerable number of cases, especially from UK and the Europe, which have laid down the law regarding the tortious liability, or what they call as the failure of command of the vessel for the non-cooperation of the crew or for the reason of incompetency of the pilot. There is, if I remember right, there is one important decision on the point, which is Ray Succulent, which was a Navy submarine that was passing through the British dock waters. And he never knew that this is a place which would be used by ships. The question was, is it the duty of a submarine to take in a pilot? Like, for example, there are vessels that come in and go out of Cochin port. Like, for example, the Cochin refineries vessels, which come in so as to take in cargo. Should it require a pilot? Because the master on board is well aware. He comes in and goes out from the port very frequently. So there would be certain vessels which are exempted from compulsory pilotage because it's a vessel that is, for example, as we said, cabotage, coastal trade. A vessel that is so frequenting the place that there is no need for a local expert so as to guide the vessel. So these are issues regarding pilotage. I guess that I should move on. I am just on the 10th slide. Now, so as to make matters more complicated, we can connect this with commercial documents and commercial principles. Like, for example, when it comes to carriage of goods by sea contracts. The sale of goods contract that has been entered into between the buyer and the seller, as part of which the cargo is being transported from port A to port B, would have some relevance in deciding the dispute between the carrier and the ship owner. Carrier and the cargo owner. Is it an FOB contract? What is an FOB contract? As law students, we all know what FOB is. CAF, cost, insurance, and that last word takes us to the maritime law, freight. What does this mean? Free on board and CAF. Just assume a situation where a seller from Kochi is selling one container full of cargo of prawns, refrigerated cargo, to some buyer in UK. One container, 40 feet container of prawns, how much would it cost? Hari would know. Something around 1 crore. 40 feet ഒരു കോടി രൂപയുടെ അടുത്ത് വരും. Order has been placed by the UK man. The local man here, the seller, he goes around, purchases the prawns, refrigerates it, packs it, places in board, and then transports it. There are certain documents that he would require, like for example, bills of lading, letters of credit, all those complexities would come. The point is this: if it is a CIF contract, cost, insurance, and freight contract, that is the CIF terms on which the buyer and seller has agreed, then the seller here has to incur the cost. That is, he has to procure the things. I means what? Insurance. He has to insure the cargo. And F means freight. He has to arrange for the transportation by finding a ship owner, pay the freight. And so he is entitled to what? Cost, the insurance premium, as well as the freight. The cargo is lost. Assume a situation where the cargo is lost. Who can invoke the policy? Because there is an insurance. Who invokes the policy? Does the property in the goods transfer on to the buyer upon the ship leaving the port, or would the property in the goods remain with the seller, entitling him to claim damages? Now we will consider the next type of contract, that is FOB, free on board. What does that mean? How do we distinguish between CIF and FOB? FOB is a situation, the word explains it very well. Free on board. On board what? On board the ship. So these are terms which we use in commercial parlance in contract, but very much related to shipping. Free on board means free on board the vessel. That means the seller here need only incur the C part of the first one, cost. He places it on board the vessel which has been designated by the buyer. He says that Maersk vessel so and so is here in Kochi. Place it on board. So he incurs the cargo, purchases the cargo, incurs the cost, places it on board the vessel, and his responsibility ends. The vessel is lost or the cargo is lost. Who has the responsibility? It was free on board. Correct. So it was free on board. So it's not the importance of CIF and FOB is not with respect to insurance. It assumes relevance when it comes to the payment of consideration. Because if I am placing the cargo on board the vessel on FOB terms, I need my money now. I am not going to wait till the vessel reach UK. How will I know that whether he will pay? Think of a situation where we live, maybe this is something that is happening in this 19th century or 18th century, because this trade has been going on like this. How do you pay? Or even now, how do I insure? ensure that he will pay. Hari knows how it is done. Correct. It has to be through letters of credit. Because what is a letter of credit? Anybody? Any of the students?
It's a guarantee given by the one bank to the buyer, seller, that after loading the things, he can encash these things.
Correct. I very much appreciate that. I would have appreciated it even better if it came from some younger students here. Letter of credit. The word explains to you what it is. It is a letter. Saying what? Saying that the person to whom it has been issued is credit worthy. That is all. Letter of credit. Otherwise, the seller here, he will not sell. Because what is the certainty that the buyer would pay? So he would say, give me the amount in full first. Then I will arrange for transportation of the cargo. Buyer will not pay. He will say, how can I pay you? Unless I get the cargo or the custody of it. So he will not pay. So there is no international trade. It stops at the first point itself. So as to facilitate this, as you rightly said, sir, we have this letter of credit. Letter of credit is a kind of a guarantee, you're right, whereby it's a kind of an assurance which is being put forth by the buyer's bank to the seller's bank, saying that, look here, this man to whom you are sending this prawns is credit worthy. We have with us his 1 crore. So once you give the bill of lading, which evidences that the cargo has been placed on board the vessel, to your bank, the bank and the bank will communicate, and insofar as the bill of lading is the evidence that the cargo has been placed on board the vessel, immediately the payment would be transferred. Which means that before the vessel leaves the port, the seller here gets his money. He wants to circulate the amount. He cannot wait up till it reaches there. He is not even concerned even if the vessel sinks in the way. It's done by the bank, through the bank. There is a simple process only between the bank, between the seller and the bank. In the early times, the best way to do is to post it. Because you don't have this communication thing. So you get a letter. That is why it's called a letter of credit. It says that this man is credit worthy. So you pay it. We will pay you provided you give us the shipping documents, as we call it. Shipping documents is a bulk of documents which includes the bill of lading as the important one. There would be other documents also, like for example, quality documents, phytosanitary certificate, lots of things like that. So that is regarding, all that I was trying to impress upon you is that contract law is also relevant. So this is all based on the Contract Act. The Indian Contract Act comes in, as well as one more statute comes in. Can you guess which one it would be? Sale of Goods Act. Right, Hari. Sale of Goods Act would come in. And the English Sale of Goods Act and the Indian Sale of Goods are not in pari materia. There are some differences between them, which would have some kind of an impact on this. We will discuss it on some other day. Now, we start with the sea. These are the areas. This is how the maritime zones have been demarcated. I am sure that you all would be familiar with it. Students of international law, you would have studied. Sorry, please give me a heads up if I am exceeding the time. I am sure that you might have studied this in public international law. If you have a paper on public international law, we used to have a paper. There is one chapter on law of the sea. One chapter. That law of the sea chapter explains to us the different maritime zones. So, these maritime zones, it was never like this earlier. These assume relevance when we discuss about maritime law. Because any discussion on maritime law have to start off with the law relating to the sea. Because the ships use the sea as its medium for transportation. So depending on where the vessel is and depending on the zone where which state would have control, there would be substantial differences in the law that would apply. That is what we find here, because now in this incident involving the foreign vessel along the Sri Lankan coast and one that is now lying in our port, the question as to the status of the vessel where it was. Now, if the vessel is in the territorial sea, the laws of the coastal state would apply on the vessel in full force, because Indian Parliament can enact laws which would apply up till the 12 nautical mile territorial sea also. The next zone and the 12 nautical mile, you can see the 12 nm, 1 nautical mile is around 1.852 kilometers. So roughly let us take it as 2 kilometers. So 12 nautical mile would mean roughly 24 kilometers from the shore. Now we have a problem there. Shore means what? Because is it the beach as we go? If we are measuring it out with a meter, with a meter, or that, where would you start it from? Would you start it from the point where the waves touch the shore? If you are doing that, at what time of the year? Because if it's a low tide or a high tide, it keeps on changing. Anyway, we'll come to that. So then you have the contiguous zone. I think that I have some slides for you where it would be more clear. The contiguous zone, the exclusive, this categorization of zones and the distance of 12, 24 and 200 that you see there was not there earlier. That is what we call as the laissez-faire of the sea. I don't think that I have time to explain much on this. Just understand the situation where the earliest of the human habitations along the sea, what would have been the interests of those ancient communities who live by the side of the sea, upon the sea? What would they have used the sea for? Correct, fishing. Any other interest? They would have gone out into the sea in their small canoes, country crafts, and fished and come back. Next, what would their interest be? The local king or the local prince. What interest would he have in addition to fishing on the sea?
Creating a navy strong.
Very good. Security. Let us generalize it by saying that security. He doesn't want anybody else in that area because that could prove as a risk for him and his country and his people. So security is there. Third interest would be transport. Moving from one place to another, he wants to use it for transportation. Other than that, the coastal state doesn't have any interest during that time. But slowly, things start changing. Sea disputes start cropping up. Then, you have a situation by around 1400s. You have a situation where the Spaniards and the Portuguese are fighting amongst themselves for the worlds that they don't know. Because it's the era of discovery. They are discovering new places, and whichever places they discover, they want a monopoly, they want to use it as their colony. So the papal board would say that the Portuguese have the south and, the east, and the Spaniards have the west. So Columbus goes and discovers America, Vasco da Gama comes to this side and discovers the route to India. From there starts the dispute where the father of international law called Hugo Grotius steps in with his concept of mare liberum. What is mare liberum? Mare means marine. Liberum means free. Free seas, very good. Free seas. Open seas, rather. It's the open sea. He came out with a pamphlet. I have the story here for you, but I don't have the time to read through it. Essentially, the story is this. A ship by the name Santa Catarina was taken over by the Dutch East India Company. And this Santa Catarina was full of spices. And it was a prize vessel. You have a concept called prize vessel at that point of time, where you can seize an enemy vessel as a prize vessel. And the company was happy that it had caught this vessel because that was a Portuguese vessel. Portuguese carack. Carack is a form of vessel used during that time. It's a sailing vessel which uses a sail because there is no mechanized vessels at that point of time. So in 1603, Jacob van Heemskerk, he has some relevance to Kerala because he was here as the the Dutch governor. You have heard of Van Reed. And I think our doctor, he would be able to tell us better because we have an expert here in maritime transportation. Doctor, I'm glad that you are here, sir. So we had this Hortus Malabaricus, yes, Hortus Malabaricus by Van Reed. So whatever, Mare Liberum concept arose out of this Santa Catarina capture, where some of the company directors felt that this is not the proper thing to do. They were Calvinists. You have heard of Calvinism? The Protestants and the Protestant movement, or the Calvinists. The Calvinists said that you have to have some kind of morals by which you should live. And this seizure of a vessel of another country, Portugal, is not the proper thing to do. And so it was not proper on your part to have done it, even within the company. So there arose a dispute as to whether you should leave this vessel back to Portugal, give this vessel back to Portugal, or the Dutch could retain it. Which took them to the question as to whether the seizure was proper, whether the vessel had the right to ply through that area through which it was plying when it was seized. That is where Hugo Grotius comes in, and he proposes that this is captured from a place that is squarely falling within the competency of the Dutch governor to do or capture. And he comes on with a concept of mare liberum with respect to areas that are open to all, and those areas within which the local governor or local prince or the king would have his exclusive jurisdiction. So that is where the free sea concept formulated the new principle that sea was an international territory and all nations were free to use it. Incidentally, this concept of mare liberum holds good even now. This is a basic, so fundamental a concept. But it was objected to at that point of time by John Selden by saying that it is not as if that seas are free to all. There are certain situations where a country would be justified in closing up its seas and preventing anybody else from entering there. So this is something that we call as the battle of books between mare clausum and mare liberum. This used to be that era, and let me tell you that if at all there is any history buff among you, this is all European concepts. What we learn now is all European concepts. It's not as if that nobody came to India prior to that. India was having, or Malabar coast was having, a substantial trade with the Arabs and the Chinese. And the Egyptian king Ramesses II, whose mummy we subsequently retrieved, had few peppercorns in his nostrils. Peppercorns in the nostrils of the mummy that had gone from Malabar. We are speaking of the Pharaohs. So it's not as if the Vasco da Gama came here for the first time and that's when Malabar was known to the world for the first time. Please read about Zheng He and his Ming treasure voyages from 1405 to 1433. One of the very interesting areas of our history where Zheng He invariably on each of his voyages touched Cochin and Calicut. And mind you, the vessels in which Zheng He came, that is the treasure voyages, it said that the number of vessels used to be around 1,000. And the size of the treasure ships was such that the vessel in which Vasco da Gama came, 10 vessels of such size could be kept on board one vessel that was commanded by Zheng He. Think of the size of the ship. It used to be a floating city. Nearly thousands of ships. We thought that this could only be a legend, mythological legend, practically impossible to have such huge ships. Until 1962 or so, when the Chinese government, as part of their excavations, they dug out a huge rudder, wooden rudder, from one of the river basins. Huge rudder. Rudder you mean, you understand what a rudder is. So the size of the rudder, so discovered, tallied with the size of the ships that Zheng He had. So that was the first instance where they realized that, because after the Ming dynasty, the subsequent dynasty had purposefully tried to erase the earlier histories. So as part of that, there was nothing tangible so as to substantiate it. They came. I don't know whether you would have read that the Chinese officers or their representatives have come to Kochi. They had come to Kozhikode so as to ascertain more details regarding Zheng He's voyages, because Zheng He died of some disease in Kozhikode and he was buried there and subsequently exhumed and taken away. They never got anything worthwhile, but from Sri Lanka they got a slab which was lying across a small rivulet, on this, underneath of which, in 3 different languages, one of which was Tamil, Zheng He's voyages had been described. Something similar to the Rosetta Stone, where you get to read the ancient script. So all that I was trying to tell you is, we had a history, we had a rather, I would say, very illustrious history, even prior to the Portuguese visiting us. So up till 58, there were some developments in international law of the sea. The 1930 Hague Codification Conference was there. The first important step was in 1958, that is the first UNCLOS. I will just share this slide so that you can read through, because we don't have time to deal with each of these aspects. Each of these are very interesting, because just see, there are 4 conventions: Convention on Territorial Sea, Convention on High Sea, Convention on Fishing, and Convention on Continental Shelf. The way in which these evolved makes interesting reading, much to discuss, but that's how it started off, 1958. Then you had the 1960, solely for the reason that the first convention with respect to the territorial sea could not decide on the breadth. What should be the breadth of the territorial sea could not be decided. Why do you think there should be a problem in deciding the breadth? Anybody? What is the problem in deciding the breadth? We know now it is 12 nautical miles. But it could not be decided for centuries together. You have the Cannon Shot Rule. I don't know whether you remember. Cannon Shot Rule, based on which the breadth of the territorial sea was measured. Never heard of it. Cannon Shot Rule. Cannon means what? A cannon that is being fired. A cannon that is being fired from a ship onto the shore, the trajectory of the cannon, the distance that the cannon could travel, is a safe distance. If the cannon couldn't reach the shore, then you don't have a problem. So the maximum you can come is to the distance up to which the cannon could, or the cannonball could travel. That used to be the Cannon Shot Rule. There is some jurist known as the Cornelius van Binkersheik. Binkersheik was the proponent of the Cannon Shot Rule. Rather, not the proponent, he was the person who gave it much wider acceptance. And Cannon Shot Rule was roughly at that point of time 3 miles, not nautical miles, 3 miles, the conventional mile. So this, in spite of the fact that we had better cannons, which could travel more than 3 miles, international law customarily accepted 3 mile limit as the breadth of the territorial sea. So for centuries together, it was 3 miles. even though it had lost its effectiveness in the sense that cannons could travel much more. As a matter of practicality, as a convenience, it was fixed as 3 miles, and internationally, generally, it was accepted as 3 miles. But subsequently, with ballistic missiles and intercontinental ballistic missiles and all, this 3-mile limit lost its relevance. And the state, that is the prince of that small local community which we started off, he started saying that I need farther and farther areas as part of my territory. On all counts, because there were areas like, for example, in Africa and in Latin America, there were extensive areas from which they used to fish since time immemorial. They were capable of traversing large distances in small canoes, and they would go and fish. Those areas, they never wanted anybody else to come and fish. So they said that this is our patrimony. Patrimony means what? Patrimony means legacy, something that has been transferred on to us by our forefathers. Nobody else should fish from there. So it's not just a security, the fishing rights was also a problem. So there was substantial variance. I think I have a slide for you on that. I don't know. Let me just see. I will not skip it. So 60 conference was essentially for the purpose of arriving at a consensus regarding the breadth. It failed. The second UNCLOS in 1960 was a failure. And then happens the third UNCLOS of 1982, which is a substantial development in the history of mankind, I would say. Because that was the first instance where mankind, cutting across all political and other affiliations and other differences, they came together, sat across a table. For the first time on any international subject, they discussed about the sea. Right from 1973 onwards to 1982, a substantially elaborate document was evolved, which we call as the UNCLOS document. Some people call it as the UNCLOS or UNCLOS, United Nations Convention on Law of the Sea. The third one, that is the 1982 UNCLOS conference, which is a model code when it comes to any dispute that mankind might face. Because deliberate, sit across a table and resolve your differences. That was the practicality of it. And while mentioning about the effectiveness of it, the strategy that was evolved is also relevant for us lawyers to understand. Because the earlier conventions failed for the reason that it was put to vote. Think of a situation where some countries say that 3-mile limit is what we propose. Others would say 6 mile. Certain others would say 12 miles. So what is the usual way in which we resolve this difference? You put it to vote. So either it is accepted or it is lost in its entirety. So in 60, the second convention, it failed because it was put it to vote, nobody accepted, the convention falls down. 82 convention, we got wiser. We said, we will go in for a package deal. Package deal means, you get it as a package. You accept this package, you take it or you leave it. If you are accepting the package, it will have something that will be in your favor, something you may have to give up. So it comes in as a package. So package deal method of discussion and settlement of issues was for the first time applied internationally, and it succeeded in the 82 convention, which came into force by around 1994. And India was a signatory. One important non-signatory was anybody? Anybody's guess? US, very good. US. US is still not a signatory to UNCLOS. Though US actively participated in UNCLOS deliberations, on one aspect they disagreed. It was on anybody? Sorry? Very good. The area. Seabed. Part 11. Seabed. Because that was the time when Soviet Union was there. And the third world nations, the non-aligned movement was also there. One vote for one country. They managed to see to it that socialist principles were brought into international law for the first time. Common heritage of mankind was brought in, which said that seabed is the common heritage of all. Actually, the common heritage principle that we now see being applied to the space started off from the seabed. Common heritage means what? All the riches of the seabed belongs to the humanity as a whole. So who will take out these riches? On behalf of humanity, the seabed authority, and distribute it to everybody was the concept, a socialist concept. Failed. Didn't work out. America said, we are not going to be a party to this because this enterprise thing doesn't have the technological know-how to do it. Who should give it? The multinational companies who have already developed it as part of the R&D have to give it for free to the enterprise. Enterprise will use that technology for free, mine it out and share it with the others. So the capitalists said, no thank you. But fortunately, that is the sole reason why the seabed is secure. Or else they would have mined and blasted the seabed, and at that point of time, it was not technologically feasible. I mean, in the sense that commercially feasible. Technologically, it was possible to take out the minerals, but it was not commercially feasible so as to do large-scale mining of the seabed. It is at the same time that you had the one in the bottom, that concept developed for the first time. Continental shelf. A very interesting concept, capable of study on its own. That concept, I guess that I may have to leave continental shelf there. Please read through continental shelf because it is one of those rare concepts. Because if you look at territorial sea as part of law of the sea, it has immemorial antiquity. Like for example, I would say in Arthashastra, Kautilya speaks of a concept called Samudra Samanya. Samudra Samanya means the prince, because Arthashastra speaks of octroys and taxes with respect to cargo that is being brought through the sea also. So Samudra Samanya is the Indian counterpart of the concept of patrimonial sea as was put forth by the Africans and the Latin Americans. So if territorial sea is a concept of immemorial antiquity, which finds presence in the UNCLOS, continental shelf was for the first time propounded in 1945 by United States and by a small officer in an office attached to the United States Coastal Security Force, which said that our coast has substantial treasures and riches. Why can't we have a definition whereby, if you look at it, continental shelf by way of definition is land. It is not water. It is a land which is lying underwater. So it's a submerged land mass of the coastal state. So that was the reasoning that was given. So it is this territory of the coastal state, even though it lies under water. And incidentally, if you look at the entire global continents, there is a geographical similarity across the globe substantially, almost 85-90%, whereby always the coastline would come, it would taper, the depth would increase, there would be an isobath, and then it falls into a deep fall towards the seabed. If you look across the continents, the globe, you find this geographical phenomenon, except for in some places like Chile in South Africa, where immediately after the territorial sea or immediately after this, there is a sharp fall. So those countries doesn't get a continental shelf. Otherwise, you have a continental shelf. So please, the definition of continental shelf was a big problem. Depth criterion, because at that point of time, if you want to exploit it, you should have the technological means. So continental shelf was in the first convention, that is the 1958 convention which I showed you, it was measured on the depth criterion, 200 meters depth, not the breadth criterion. Subsequently, with technological advance, you could exploit from anywhere, even from the seabed. So the depth criterion had no meaning. That is one of those classic examples where law catches up with scientific development. Law always lags behind scientific developments, and it takes some time for law to catch up with science and technology. So this is one of those instances. I'm skipping all this. There are certain other issues that are there in law of the sea, which still that is in existence. Well, I think that I don't have time to go into all those. In this slide that I've just touched upon everything that I've said. The enterprise is there, marine scientific research is a problem, dispute settlement I have not touched upon. Of course, that baselines I think I will just explain to you. And the South China Sea dispute is now in its zenith. So we have some problem with respect to baselines. We stopped it there. Where do you measure out the baselines from? Especially during the low tide or a high tide. Let us make the situation even more worse by pointing out that there are some islands lying close by. This is something that we had, the problem that we had between India and Sri Lanka in the Pak Straits. There are some islands lying between, which the Tamil population from Tamil Nadu used to access, as well as the Sri Lankans, since time immemorial. I forget the name of that island. Kachativu? Kachativu, yes. So, now you have an international boundary line which separates with an equidistance principle. So, the drawing up of the baselines, because think of a situation like this. In the map of India that we draw, it is a seamless line along the shore. But once you go close, this is the way in it is. So, where do you fix that tape of yours so as to start measurement? From the tip of that shore or from the exterior portion of that island? Where do you start it from? And to make matters worse, there are places like, for example, in Lakshadweep, which are islands. How do you fix it? There are countries which are islands, a group of archipelagos. Philippines is the largest archipelago. Indonesia. There are archipelagos which would legally claim that we don't require the benefits of an archipelago. For example, Japan. All through the deliberations in UNCLOS, Japan, though a group of islands and squarely falls within the definition of an archipelago geographically, said that we are not an archipelago. We would rather choose to call ourselves as an island, just like Sri Lanka. Because of that package deal thing. If you fall within the category of an archipelago or if you fall within the category of a island state, the benefits that flow were different. So they weigh their benefits and then they decide. So I would request you to study the UNCLOS 82 deliberations, especially during this time, because that was one of those best examples where we were able to settle our differences on a very peaceful, conciliatory note. So that is it. Now we come to that invariable session in every speech where I rush through the slides in lightning speed. We have reached there. So just see, this is the baseline of India, baselines of India. And just see the Lakshadweep, the area that the lines enclose within itself is what? It is not the territorial sea, it is the internal waters. So better than territorial sea. So from the baseline, the water body that is lying towards the shoreline is what? It's the internal waters. And it is from the baselines to the seaward side that the territorial sea starts. So internal waters is as good as the land, just as the territorial sea. But this is where I would like to, this is another area. I think I will just explain this and leave it there. That is the situation of contingo zone. Why should we have a contingo zone? You saw that contingo zone is the area that is just next to territorial sea. Why should we have a contingo zone? Let me take you once again to that, since, yes, this one. This is another map, as a bird's eye view. You have a contingo zone of 12 nautical miles just beyond the territorial sea. Why do you need a contingo zone? The need for a contingo zone is there because if your territory ends at 12 nautical miles sharp, you find an offender doing something illegal within your territory, and by the time that you come to catch him, he moves out of your limits, and then he is in a place where you won't be able to go and apprehend him. So for the purpose of effective enforcement of local laws within the territorial sea, invariably you should have a belt along the coastline, along this 12 nautical mile limit, where you will be entitled to enforce the laws. So for that limited purpose, it's not a sovereign area. So if territorial sea is the sovereign property of the coastal state, contingo zone is what? Contingo zone is not sovereign area, but an area over which you would have some jurisdiction. For what is the question? So UNCLOS says, let me just take you straight away to that provision. This is why it was created, and this is what UNCLOS says. 1. This is the contingo zone, it is 12 nautical miles, plus from that is 24 nautical miles. Prevent infringement of customs, fiscal, immigration, and sanitary laws. That's all. These are the 4 interests that you can possibly have: customs, fiscal, immigration, and sanitary. That is why during COVID times, when a vessel has to enter, vessel will have to go through the screening before it enters our territory. There is no point in screening it after it enters our territory. India and many other countries said, we need one more interest there. That is security. International community did not agree. They refused it because security is a very difficult, nebulous term. It would be as good as extending the territorial sea further. So India signed the convention, but by that time, earlier we had the 1976 Territorial Maritime Zones Act, which said security of India. So as per the local law, the 1976 Act provides that India has a security interest in contingo zone. But if you test it at the touchstone of international law, this claim of ours is difficult to stand. This problem came to the fore in a big way in 2 cases. One is, as you rightly pointed out, the Enrica Lexi, and the other is a case called the Seaman Guard Ohio case, where a security vessel was arrested and it was taken to Tuticorin, and all the naval personnel were arrested because they had a huge cache of arms, AK-47 rifles and all, and we said that this vessel and the arms doesn't have license issued under the Indian Arms Act. They said that we don't have to have it because we are there for rendering maritime security to other vessels that are passing through Somali coast. We happen to come here through only up to the contingo zone. You cannot enforce, put it simply, their contention is that you cannot enforce your local laws in the contingo zone. But in both these cases, Indian courts said no. And we have a situation now where IPC as well as the CRPC, as it stood earlier, has been extended up till where? Up till the exclusive economic zone. So, exclusive economic zone is 200 nautical miles. IPC as well as the CPC by notification has been extended up to 200 nautical miles, which means that the coastal police station in Fort Kochi has jurisdictional limits of 200 nautical miles. I think I will leave it there. I had some more points because I had not reached because for history buffs again, there is something called the Ganj-e-Sawai incident. I had purposefully put in this kind of snippets because maritime law is known as one of the most driest and the complex branches of commercial law, very dry, and nobody can sit through a class on maritime law for more than 1 hour. So it has been my invariable attempt to put in something like this so as to retain your interest. But the unfortunate thing is that we end up with this alone, and the substantial part of the substance have not been touched upon. Anyway, Ganj-e-Sawai is a very interesting incident on piracy. It assumes, because it was those incidents where the Mughal king, Aurangzeb's vessel that was returning from Mecca, was taken over by a pirate by the name John Avery. He is one of the only pirates in the history who amassed substantial wealth, and he was never caught, intercepted. We don't know where, because this Ganj-e-Sawai was a huge vessel, and it had on board precious gems and immense treasure on board. And one part of the treasure was large number of young women who had been chosen from different parts of the globe so as to come to the Mughal harem. All these women were there on board. John Avery, because it's very thrilling encounter. You should read it because the kind of persistence that John Avery had. In small 3 or 4 vessels, he comes and confronts Ganj-e-Sawai, which is many times bigger than his vessels, which is armed to the teeth, and he subjugates the vessel, kills all the people, vanishes with the entire treasures, never to be found again. Just check through. Now, I guess we have just dealt with the ship, the sea. The ship still remains. I will share the slides with you. I'm so thankful to NUALS and the Indian Law Institute for giving me an opportunity. And thank you very much for patiently listening. Thank you very much.
Respected Honorable Justice Syam Kumar sir, the talk was excellent, but you disappointed me by omitting the ship which I represent. I have only one question.
Yes.
You have mentioned considerable thoughts on the piracy part of maritime law. What would happen if a mutiny happens on board? Whether it can be treated as a piracy or mutiny is totally different concept.
Thank you, Dr. Shivaprasad. It's always a pleasure to take a question from you. Dr. Shivaprasad, incidentally, was the Vice Chancellor of APJ Abdul Kalam, was of the APJ Abdul Kalam University, a very eminent researcher, and I had the pleasure of releasing one of the books, excellent books written by Dr. Shivaprasad. You have it with you, sir, yes. He was an alumni of Ship Technology Department of the School of Legal Studies. The answer is revolt or mutiny on board a ship is what is called as barratry. There is a separate terminology for a mutiny on board ships. It is barratry and it is not piracy. Having said that, SUA Act 2002 defines all such acts by a single term as an offense against a vessel or a maritime platform or a watercraft. So if there is a mutiny on board a vessel and within the Indian waters or Indian limits, it is something that will squarely fall within a crime that could be proceeded against under SUA Act. So your answer to the question is, it is a crime, even though technically it might not fall within the definition of piracy, for the reason that piracy as defined now in the latest Maritime Piracy Act evolved by the Indian Parliament envisages 2 ships. But fortunately for us, we have the 2002 SUA Act that is in place, based on which action can be taken. And whether, I don't know whether this is a good thing or a bad thing. SUA is a complete code in itself. I remember when I was appearing for one of those fishermen in Enrica Lexi matter, I reached a situation where I found it very difficult to put forth a very sustainable case on behalf of this. There were two fishermen who had died. I appeared for one of the family members of one of them. So I contacted my superior, S. Venkateswaran, who is a doyen of maritime law, under whom I was practicing as a junior. And he told me, Syam, you won't be able to succeed for your client unless you invoke SUA. Frankly, though I was a student of maritime law and I had completed my LLM in maritime law, that was much before SUA, and I had never even heard about SUA at that point of time, frankly. So I pulled out this statute and I read through it, and I was shocked to find that it was a statute which fixed strict liability on the offender, whereby burden shifts onto the sailors to prove that they had not committed this. Can you believe it? A criminal responsibility being fixed, saying that because all that I needed to prove was that this man had died out of that bullet. Unlike a situation where the accused can stand in the box with his hands folded, putting all the burden on the prosecution to show that he has been guilty of what has been charged with, SUA envisages a situation where the burden shifts on to the accused. And to make it even more worse, there is such a casually drafted provision in SUA which says death has to be punished with death. So I seized this opportunity. I filed a writ petition saying that this is a matter, but one catch is that SUA can be initiated only by the central government. The Kerala police cannot initiate a SUA. So the FIR that has been laid by the Kerala police does not help me. So I required a situation, because SUA Act is one of those legislations which has been included in the schedule to the NIA Act. NIA Act. So it has to be through the center. So I impleaded the central government and all, and filed, just to take a chance, and filed a writ saying that this is something that has to be done by them. And simultaneously, I filed the admiralty suit also. Immediately after this, they came and said that we are ready to settle. Because something that they effectively used against me was that how on earth can you possibly contend that the Italian Marines are terrorists? Because SUA applies essentially against acts of terrorism. So this is not an act of terrorism. How can you, but the way in which the statute has been worded is such that whatever had been done, allegedly done by them, fell squarely within the provisions of SUA. So rather than fight it out, they decided we will settle it for the amount that you have suggested. So, sir, the answer to your question is that yes, SUA would be of help in such a situation.
So my question is, sir, India, you were mentioning about the extension of security interests by India to the EEZ. So should that be seen as a violation, or should India be pinpointed as a violator of the UNCLOS? Or do you think there's a trend among the countries around the world wherein many of the countries are in fact extending their security interests out into the EEZ? China is one example. So, do you think there is a kind of an unsettling of the settlements in the UNCLOS? And what are your suggestions with respect to that?
That's an excellent question. Especially from a student of mine, I am so happy to take it. I was earnestly, because this issue was specifically raised by Italy before the ITLAS. ITLAS, the Enrica Lexi matter reached ITLAS. Thereafter, it went to the PCA. In PCA, before PCA, this was a specific question that was raised. The validity of the Indian statute, which goes beyond what is envisaged under UNCLOS. Insofar as the matter was settled, no decision on that point. If you read through that award of PCA, it specifically says this question not answered. But as you rightly said, the only possible way that we may be able to justify this transgression, if we may say so, is by saying that there has been a consistent international practice that has developed. Because customary law, because we have different sources of international law. One is that there is a consistently followed international custom or a practice which has graduated to a level of international custom where large number of countries practice this as their something customary rule of law. Then that is a reason where we will be able to justify that this is not something that is transgressing upon the international law. Because I think that India will be able to very effectively put it across. For example, I think China and almost nearly 40 or 50% of the countries across the globe are now claiming extended territorial seas. Personally, left to myself, I would say that it is high time that territorial sea should be extended to 200 nautical miles. Because if you have an exclusive economic zone up till 200 nautical miles, the reason that was put forth by United States and other countries so as to shoot down our proposal to have a 24 nautical mile territorial sea no longer survives in 21st century. In 21st century, because that's something that I couldn't touch upon, we have this concept called innocent passage. So even though territorial sea is a sovereign area, foreign vessels have the right of innocent passage through the territorial sea. What is innocent? What is passage? What constitutes a kind of an affront on the sovereignty of the state? What is meant by peace, good order and security of the coastal state? Which are the requirements that should be there so as to comply with this innocence as per UNCLOS? All these are nebulous concepts, but still it is high time that the territorial sea extent is increased, and there is valid reason so as to claim a 200 nautical mile territorial sea, especially because, as you rightly said, there is a consistent international practice where many of the major maritime states are claiming extended territorial seas. On this point, I would also request you to read through an incident called Black Sea Bumping Incident for those history enthusiasts among you. Black Sea Bumping Incident. If Anil permits, I will just take 2 minutes just to explain what Black Sea bumping is. Interesting situation. In the height of Cold War, when United States and USSR were at each other's throat, United States decided to test the principles of freedom of navigation. Because freedom of navigation is a principle whereby through the territorial seas of foreign states, a foreign vessel can pass, provided it is an innocent passage. This was because of exactly for the reason that is now playing out in Hormuz. There are lots of small straits, bottlenecks, Strait of Hormuz, Strait of Malacca, Strait of Gibraltar, Bosphorus and Dardanelles. All these straits are small chicken necks through which vessels have to pass through invariably. Because if Strait of Hormuz is blocked, then there is no way out from the Persian Gulf. If the Strait of Gibraltar is blocked, there is no entry or exit to the Mediterranean Sea. If the Strait of Malacca down the south is along the Indonesia is blocked, no way up to Japan. So these straits are so important. The reason why the maritime powers say that territorial sea should be to the bare minimum is that otherwise these territorial seas would swallow the strait, and the strait becomes what? Internal waters. So Iran or rather Egypt, instantly Bosphorus is a strait that cuts across Istanbul city. Just like I used to tell in my class, our Perendur Canal. It cuts through the city of Istanbul. So if you choke the Strait of Bosphorus and Turkey doesn't permit any vessels to move out, then you don't have an easy way to reach Black Sea. So the reason is, insofar as this innocent passage principle, it envisages that you can have an innocent passage through the territorial sea of others. Freedom of Navigation Program, United States, at the zenith of Cold War, had sent a frigate, a warship, through Soviet territorial sea. Just to test, because Soviet Union is a signatory to UNCLOS. If you are abiding by the terms of UNCLOS, and that is something that is actually a part of their American realism, the realist jurisprudence followed by the American jurists, whereby they want to test out the law in the book by applying it to a fact situation. Realists would say that this book is only future law. You have to apply it to the fact situation so as to understand, just like Article 21. Only when you apply it to a situation, you understand its hues and colors and the possibilities that it's capable of giving. So this vessel that was sent through through Soviet Union was encountered by another vessel, and the Soviet vessel came and gave a nudge to the vessel. That is what is known as the Black Sea bumping incident. You will get even pictures and videos are there on YouTube. So freedom of navigation is now a settled sacrosanct principle. So the answer to your question would be that this Indian incorporation of security as an additional interest into the provision regarding contiguous zone can be validly sustained in an international forum based on the principle of consistent customary state practice. Thank you.
I have a doubt. It's regarding environment also. It's regarding ocean dumping. So how feasible it would be to kind of for our entrepreneurs to set up facilities that could treat garbage in our ports and our coastal areas? Like, does it falls under the jurisdiction of maritime law as well?
It doesn't. As far as if you're doing something along the coast, following the local legal requirements, I don't think that it has anything to do with maritime law as such. It may be something that falls within the municipal law.
And others that passes through the Indian Ocean that is dumping plastic.
Oh, that's
waste.
a different question altogether. Correct. You are speaking of the waste that is emanating from ships.
Yes.
Again, it's something that would fall within, depending on where do you find that vessel? Is it within the territorial sea? If it is in the contiguous zone, you may not be able to do that. But maybe if it is in the exclusive economic zone, well, contiguous zone, exclusive economic zone swallows in contiguous zone also. If you are able to show that it is something that would detrimentally affect the environment, because EEZ, exclusive economic zone, is an area where the coastal state is entitled to evolve laws for protecting the environment also. So it can be brought within that and action can be taken.
Thank you, sir.
Thank you.
Now I request Krishna sir to hand over a memento to Syam sir.
Good afternoon, friends. It's always a pleasure to be part of an event in which Justice Syam is a speaker, for the simple reason that he will make us feel young at least by 25 years. I had a feeling that I was sitting at one of those lectures at the law school, listening to the speaker on the topic law of the sea. So thank you, Justice Syam, for making us feel younger. Maritime law is one of the very few branches of law which I would say is international in nature, for the reason that ships travels from countries to countries or from continents to continents carrying goods. Subjecting these vessels to different legal or regulatory regimes can lead to a very chaotic situation. Therefore, for the proper development of maritime trade and commerce, it is necessary that there should be uniformity of laws. Now, how do we achieve this uniformity? There are two ways. One is you become part of the international conventions which are ratified by countries, or you make legislations in the country. Like for example, in India, you have Article 253 by which you can give effect to international conventions. Though India is a maritime nation for centuries, we were lagging behind in legalizing or recognizing international conventions. As Justice Syam had referred, it was in 1993, in the classic case of MV Elizabeth, Justice Kochudaman, Dr. Kochudaman, highlighted the necessity to have domestic legislations relating to admiralty law. And incidentally, I don't know how many of you sitting here knows that Justice Syam is a successor of Justice Kochudaman, because both of them were partners of the erstwhile Southern Law Chambers, which was probably one of the only shipping law firm in Kochi at that point of time. It took another 25 years for us to have the Admiralty Act of 2017, and still another 8 years where we are having this 5 new legislations on maritime law. The Carriage of Goods by Sea Act has now incorporated the Hague-Visby rules. The Bills of Lading Act has recognized the electronic bills of lading. The Merchant Shipping Act has incorporated SOLAS and MARPOL conventions. All these are all welcome change. I'll point out one instance in the Merchant Shipping Act which will throw light on the fact that we need to align our laws with international conventions. Section 352 of the 1958 Merchant Shipping Act talks about limitation of liability. A ship owner is entitled to limit his liability, irrespective of the fact that probably the captain was negligent in navigating the vessel which caused the casualty. Now, the amendment to the Merchant Shipping Act was brought about in 1976 based on the 1976 Limitation of Liability Convention. One of the important features of the 1976 Liability Convention is Article 4, which talks about conduct barring limitation. In simple terms, it means the shipowner cannot limit his liability if he is privy to the incident, which means if he has done it deliberately or with intention to cause loss, then he cannot limit his liability. When we incorporated the provisions of 76 Convention into our Merchant Shipping Act, this particular provision, which is Article 4, was omitted. Now, there were 2 Bombay High Court judgments which held that since conduct barring limitation is not there in our Indian statute, the owners have an absolute right to limit their liability. If we accept this proposition, the difficulty it would face is it would throw upon everyone is that any ship owner can deliberately set fire to a vessel or sink a vessel and can still claim limitation of liability. In the 2025 Merchant Shipping Act, Section 163 has brought back this conduct barring limitation. So what I was pointing out was, even the statutes that we have, if it is dealing with maritime law or for that matter any international law, it has to be in conformity with the international conventions. Syam has referred to the 5 statutes. Of course, some changes that they have made in these statutes may not be very relevant and the old provisions still continue. So maybe I can say that this is old wine in new bottle. But then again it is a matter to be delved upon or decided by the courts when called upon to do so. I think I should stop with this and thank Justice Syam for his eloquent speech. It was always a pleasure to listen to Justice Syam, and I hope that all of you present here have also enjoyed the talk rendered by Justice Syam. Have a good afternoon. Thank you.